Thank you for visiting the Coin Lady channel again. The legal struggle between Ripple and SEC is winding down, folks. The SEC has submitted its final reply brief together with the exhibits. It is expected that the ongoing legal dispute between SEC and Ripple will be resolved soon, as it began on May 8, 2020. With the recent delivery of the SEC's final reply brief, the matter involving Ripple and the SEC has progressed to the finalization stage. To determine which redactions are most suitable. To discuss the submission, which is considered secret, all stakeholders will meet for one last time. In the matter of Ripple v. SEC, the SEC has filed their last brief, along with the submission of its final response and supplementary materials. On May 8, the long-running legal dispute between Ripple and the U.S. Securities and Exchange Commission is finally going to end. The final reply brief about the Ripple versus the lawsuit has been submitted, according to the established announcement. The details of the document are being kept under wraps by the SEC, but a redacted version is scheduled to be made public on May 8, 2024. Ripple and the SEC will collaborate to scrub the document of any sensitive information before this occurs. Is this a major turning point in the Ripple's lawsuit? The Securities and Exchange Commission Shane panel recommended a nearly $2 billion fine for Ripple in its initial filing. Federal securities legislation were violated, according to the SEC, when the business sold its native token XRP to institutions. In addition, Ripple asserted that the suggested penalty was excessive and requested a settlement amounting to no more than $10 million. Furthermore, attorneys believe that the most alluring final report will handle Ripple's rebuttals to the agency's original recommendations for solutions. It is possible to appeal the final decision. An extension till 2025 is possible in this scenario. In the month of December 2020, Ripple Labs and its leadership were the targets of a complaint filed by the Securities and Exchange Commission, SEC, which accused them of violating federal securities laws and engaging in unlawful activities within the cryptocurrency business. Also, the business was said to have made money by selling in unregistered securities. Metal Wayman, a prominent figure in the cryptocurrency industry and a prolific Twitter user, has shed some insight on the SEC's case against Ripple. The SEC's most recent filing about damages and disgorgement has been his primary emphasis. On the subject of victims and why disgorgement should be the preferred remedy, he argued that the Securities and Exchange Commission had not made any compelling contributions. If you believe Metal Lemon, the SEC is mostly reliant on a single district court ruling called SFC 6 New, which determined that when stockholder investments are illegally inflated, the pecuniary injury threshold is reached. This year, the Securities and Exchange Commission took the position that institutional buyers who paid a lower price for XRP than others are the ones who have been financially hurt by the inflated price. The reason behind this is that inflation is clearly indicated by the raised price. Metal Man, in contrast, expressed doubt about the correct reading of the facts of this case, claiming that it was an oversimplification of the comment made by the Second Circuit in the case of Second v. Seville. He also noted that the judge who wrote the FS ruling referred to it as Metalvaman and that the SEC's dependence on E-Fresh as a precedent for determining pecuniary harm is problematic. It was also deemed improper to bring up a not-for-publication ruling, as he was cited as saying in the past. The SEC's reason for discouraging it is the most flimsy authority that possibly exists. There are good grounds for the court to order an injunction and a deterrent, as stated in the lawsuit that the Securities and Exchange Commission filed in court, claiming that Ripple broke securities laws. The sale of XRP currencies that have not yet been registered remains Ripple's principal activity. A judicial order would be warranted, according to the Securities and Exchange Commission, to prevent more violations, given that Ripple intends to release more unregistered crypto assets. In the brief that was given to the court, the Securities and Exchange Commission states that Ripple's newly formed company structure could be linked to possible future violations. Even though Ripple's acts are illegal, the company nonetheless has enormous incentives to sell XRP. The fact that its on-demand liquidity has been significantly enhanced further proves this point. In its application, the Securities and Exchange Commission sought injunctive action despite having sued over those transactions based on this line of thinking, as well as Ripple's refusal to admit guilt and the apparent shifting of blame. Ripple's claim that investors have not lost money is inconsistent, according to the Securities and Exchange Commission, SEC. Junior harm can happen when disclosure mistakes cause prices to be inflated. It is likely that the Securities and Exchange Commission will grant injunctive relief and discouragement, even though they made a profit from buying and selling XRP. This is because the price was artificially inflated due to a lack of transparency. He was aware that the court might decide that Ripple's institutional investors were harmed financially, following the lead of eFresh. Nonetheless, this remains quite unlikely. As a result of that action, his actions exposed the Securities and Exchange Commission's (SEC) contradictions, such as its reliance on a non-binding case to support its claims and their defense of his discouragement without offering evidence. Metal Mon may have issues with the SEC's method, but the court filing shows that the SEC's goal is to stop further violations by using injunctive relief and enforcing fines and penalties that deter and punish such actions. It also highlights the SEC's resolve to bring Ripple to account for its actions and the ways in which it neglected to offer suitable disclosure standards in its business dealings. The final decision in this matter may have far-reaching implications for the cryptocurrency industry's regulatory strategy from the standpoint of the SEC. In this debate, the Ripple counterattacks are focusing on the international community, and the cryptocurrency enthusiast and legal expert community is watching the SEC's actions very closely. Stewart, Ripple's chief legal officer, responded to the SEC's stance in the appellate brief by stating that the regulator's credibility is steadily declining. He made the observation that the SEC may confound foreign financial authorities who have created robust cryptocurrency regulatory systems. While critiquing the gender gap in regulatory enforcement, Mr. Alterity bemoaned the agency's lack of consistency. On the other side, experts are hoping that the XRP case will conclude with a final decision by September. The video concludes with that. It would mean the world to me if you could subscribe to my channel and like it. Muchas gracias, depart.